بسم الله الرحمن الرحيم والصلاة والسلام على رسول الكريم. السلام عليكم ورحمة الله تعالى وبركاته, and welcome to Fiqh al-Muamalat online classes. And today's topic is a continuation of the previous discussions which is related to Mawdu' al-Aqd, or the subject matter, which is the price and the goods. And we have discussed so far the first requirement, which is the legality of the subject matter, means be legal from Sharia standpoint, from the custom standpoint. And number two, that the subject matter should be known to both parties, whereby a disclosure of informations is required in order to remove the degree of uncertainty and remove the gharar. So the buyers and the sellers, they will know what they are buying, how much they are buying, the kind of specifications of the asset they are buying, the kind, the spec, the colors, and many details. Of course, later on when we go to the istisna, we will find that this one is very crucial requirements in the istisna, and it is a bit less importance when it comes to salam. We will defer that kind of discussions when we cross those contracts. So let's carry on the discussions to cover the three remaining conditions of the subject matter. And the third one is basically the capability of the contracting party to hand over the subject matter, meaning able to give the money in the which is the price, and able to hand over the asset. And here's basically we're talking about two types of requirements, sub requirements you may say. The first one, we are talking about the ownership. So you have to have an ownership over the asset that you will be able basically to transact and deal with it, give it as a hiba if you want, sell it to a third party. But if it doesn't belong to you, you have no right over the asset to exercise any kind of transactions, being a sales or gift or work or anything. So first thing is ownership. You have to have a valid ownership on the asset to allow you to transact and dispose it from your ownership. And if you don't have ownership, it could be managed through agency, meaning that you may have agents on your behalf that he's basically dealing with asset to sell it to a third party or give it away to a third party as a hiba or any kind of transactions. So either you have an ownership, because he's not allowed to sell what you don't own. And if you don't have ownership, if you have ownership but you don't want to transact yourself, you could appoint agents that he can handle the transactions on your behalf. Then the agent will have an authorization to act on your behalf. Otherwise, he will be a kind of aqd al-fuduli, or the act of the meddler, that we will discuss it in details in the wakala contract. Now the second one is the ability to deliver the asset. Ownership is not sufficient, but the ability and the capacity to deliver. Delivery is another requirement. Why? Because sometimes you may have ownership on asset, but you cannot deliver it because it's under other obligations, or it is not within the authority to deliver it, or you are not capable to do it. Example, scholars normally say, don't buy fish in the sea and bird in the sky. Scholars don't allow buying spray animal or stray animal because of the issue of the delivery. You may have a bird that belongs to you. You may have a bird that you have an ownership. You may have a bird that has a name, and everyone, it belongs to you. And the problem is that bird is not anymore in the cage, but up there on the tree. And even though you have ownership on that bird, but you cannot sell it because you will not be able to deliver that bird, because if you try to catch it, maybe it will fly far away. Then the delivery will not be executed accordingly. And as a result of that, you cannot sell the bird, of course, unless the bird is trained in such a way that you may release it and it goes to the tree up there. But if you call the bird comes back and it will be back in your possessions, either physical possessions or constructive possession, like for example in the cage and so on and so forth. So here, but a normal assets or normal basically animals, spray animal, stray animal, fish in the sea, bird in the sky, spray animal, stray animal, you can't basically sell it because you don't fulfill the ability to deliver the asset to the other party. So this requirements is talking about capacity and ability to the person to deliver, and it requires ownership and also delivery. The other point is that the existence, the subject matter should be in existence, meaning it does exist. It doesn't mean it is a present with you. No, it could be in your house, it could be in your office, it could be in the warehouse, it could be your friend, it could be with your partners, it could be in a different city, it could be in a different country. It doesn't matter. But what is matter, it does exist somewhere. But what is not allowed in Sharia is that that asset does not exist at all, which is called in Arabic al-ma'doom, meaning bay al-ma'doom. It is debated, and of course the message of the scholars do not allow it. You cannot sell something which does not exist with the exception of the three contract: salam, istisna, and ijara. Salam contract, the subject matter does not exist, but it's allowed. Istisna, subject matter does not exist during the execution of the contract, but it is allowed. And the same goes for ijara. We will discuss this one, of course, in the relevant section according in the future, inshallah. But at this point, the general rules of Sharia that something does not exist, which is ma'doom, is not allowed to be sold, with the exception of salam, istisna, and ijara. If you have salam, fine. Istisna, fine. Ijara, fine. Other than that, it's not allowed. The existing is a requirement because it's not allowed to sell what you don't have. And as a result of that, if you want to design your product or you want to design your facility, and you are under the requirements to sell something which does not exist, so you have to opt for salam, or you opt for istisna, or you opt for what's so called ijara, or you move to the tabarru'at contract, where there is a flexibility on that as well, as we are going to discuss it in the future. But general rules on the compliance, the asset must be in existence. The other requirements is basically, if I may stay here in these requirements, this is why here the scholars do not allow selling the fruits and the vegetable before their complete perfections. If their appearance is perfected and they are ready, so you can sell it. But if it is in the process, so you're not allowed to sell it, meaning that you cannot buy a tree and wait for the fruits. So either you buy the tree and use the tree on the spot immediately, or you wait until the fruit is ready and it reach its perfections of readiness, then you can purchase, but you cannot purchase and wait. That's the because it's fall under bay al-ma'doom. The fruits are not ready for crop or for harvest or for cutting, so basically it falls under the bay al-ma'doom. Of course, with the exception of salam, if you want to do it, you have to do it through salam. Salam, yes, you can buy things which does not exist in the vegetables and agriculture product, but that one is designed based on salam. I'm talking about a normal transaction, normal sales. You go to the farm, you go to the tree and try to buy. If it's not ready, it's not allowed to buy. Either you buy a tree to use the tree differently for whatever reason, but if you are targeting the fruits, you have to wait until they are ready or about to be ready, and they are close to their perfection, so you can proceed with the transactions. Otherwise, you have to go to salam transaction. And the following point we'd like to highlight is basically the subject matter is not under other obligation, which is somehow indirectly could be also parked under the ability to submit the subject matter and deliver the subject matter, meaning that the subject matter is not under charge, the subject matter is not under rahan, the subject matter is not under strict financial obligation that doesn't allow the owner to transact with it in a very free manner. So if it has that kind of obligations, it could be additional restrictions that doesn't allow you to proceed with selling or buying or leasing the subject matter. So this is overall the general requirements of the subject matter. And if I just recap, the subject matter, which is a price and goods, and could also change, depends on changing of the nature of the price and the goods, has in overall 5 requirements. The subject matter must be legal. And number 2, the subject matter must be known to both parties. Talking about the specification here, should be capability of handing over the subject matter, and also the subject matter should be in existence and free from any kind of financial obligation that puts some kind of restrictions on the movements of the asset. If all these requirements have been fulfilled, we assume that the subject matter in terms of price and goods have fulfilled the Sharia requirements and is ready to go with the financial transactions without any violations of Sharia requirements. With that, thank you very much, and Assalamu alaikum wa rahmatullahi ta'ala wa barakatuh.